Good evening. I and Prachi, on behalf of Delhi High Court's Women Lawyers Forum, welcome you all to the 12th and the last virtual canteen of the year 2020 with a debate on capital punishment. Capital punishment has long engendered considerable debate about both its morality and its effect on criminal behavior. Formal execution of criminals has been used in nearly all societies since the beginning of recorded history. Before the beginning of humane capital punishment used in today's society, penalties included boiling to death, flaying, slow slicing, crucifixion, impalement, crushing, disembowelment, stoning, burning, decapitation, and dismemberment. In earlier times, the death penalty was used for a variety of reasons that today would seem barbaric. The fight between those who support capital punishment and those who oppose it is rather simple compared to many other debates. Those in support of capital punishment believe it deters crimes, and more often than not believe that certain crimes eliminate one's right to life. Those who oppose capital punishment believe, first and foremost, that any person, including the government, has no right to take, just one second, has no right to take a life for any reason. They often believe that living with one's crimes is the worst punishment, and that the threat of capital punishment will not deter a person from committing a crime. They also believe that the risk of executing an innocent person is too high. The debate between these two sides is often heated, and we have seen it in our own group. And that led Ms. Mrinalini Sen to come up with this brilliant idea to organize a mock debate on the subject. We are thankful to the debaters who readily agreed to participate. It is to be noted, however, that this debate is only an academic exercise, and the views expressed by the debaters are not necessarily their personal views. We hope that by way of this debate, all of us here are able to develop a deeper understanding of the subject and form our own informed opinion. Prachi, please take over now to elaborate on the flow of the debate.
Thank you, Ms. Tandon, for such a succinct introduction of the topic. Before we start with a brief introduction of the speakers, I would like to enumerate the format that we will be following for today's session. The motion for today's debate is, should India retain or abolish the death penalty? There are two sides. One team is supporting the motion, that is, India should retain the death penalty, and the other team will argue against the motion, that is, India should abolish the death penalty. The team supporting the motion will begin speaking. The first speaker will speak for a total of 10 minutes, followed by the first speaker of the other team. Thereafter, the second and the third speakers of the respective teams shall speak for a span of 7 minutes each alternatively. Thereafter, we will open the floor up for questions from the audience or from either of the teams as well. The members of the audience are requested to type in the questions, and we will pose those questions to the speakers. I hope you enjoyed the session. Now I request Ms. Tandon to introduce the speakers speaking for the team in favor of the motion.
Thank you, Prachi, for a comprehensive introduction of the structure of the session. I now so our polling is not working, unfortunately, so we would have to do away with the opinion poll that we had planned in the beginning and at the end of the session. However, our views remain our views, and I hope that we are all able to form a deeper understanding, as I had said earlier, of this subject. The idea is just that there is no winner or loser here. So we will be doing away with the poll here. It gives me great pleasure to introduce the speakers for today's session. The team advocating and speaking for the motion comprises of Senior Advocate Ms. Geeta Luthra, Ms. Shweta Kapoor, Advocate, and Ms. Kritika Gupta, Advocate. Geeta ma'am is no stranger to all of us, but still I'm doing with this formality. Ms. Geeta Luthra is a designated Senior Advocate. She has been practicing in the Supreme Court of India and the Delhi High Court and various other courts. She is the Vice President of Indian Council of Arbitration, FICCI, member ICC Chapter Core Committee, member Law Asia and International Academy of Family Lawyers. She is also a member of the Women's White Collar Defense Association. She was awarded the prestigious Inlax Foundation Scholarship for Law at Cambridge, where she pursued her LLM and MPhil in International Law. She is currently an additional Advocate General for the state of Haryana and a senior counsel for the Union of India at the Supreme Court. Ms. Luthra has argued several prestigious matters in human rights, criminal law, and matrimonial law. She has lectured at various national and international universities and law schools. Ms. Luthra has secured landmark judgments in various fields.
Can you stop this?
Ma'am, it's just 2 more lines remaining. Please allow me, ma'am. Has secured various judgments in various fields and has successfully defended rights of several members of the society, including women, children, and transgender. She has also been a lead counsel in landmark arbitration and land acquisition matters. Ms. Shweta Kapoor. Ms. Kapoor graduated from the prestigious Campus Law Center at Delhi University and holds 13 years of experience in hardcore litigation to her credit. Being a graduate from a liberal arts college, she finds the social and political impact of legislations is something she finds fascinating and always dwells into. As a lawyer, she has always tried to bring empirical impact of law into her practice. She believes that knowing the law is truly an empowering experience, and it is the first step in bringing justice in an unequal society. Ms. Kritika Gupta. Ms. Gupta has been practicing law since 2015. She is a senior associate in St. Lake's Chambers, working on both litigation and non-litigation matters in the firm since 2016. After completing her graduation in BSc Chemistry from St. Stephen's College, she pursued law from Faculty of Law, Delhi University. She is presently assisting on matters pertaining to family law and arbitration, intellectual property, Benami laws, service laws, property disputes, and company law. She regularly appears before the Delhi High Court, family courts, and district courts across Delhi NCR. Over to you, Prachi, to introduce the team debating against the motion. Prachi, are you there?
The team speaking against the motion comprises of Ms. Keith. The team debating against the motion comprises. Is my audio? Is my video on? Is it working?
Screen is frozen. Prachi, try switching off your video and speaking only. I think we have lost Prachi from here. I'll just take over till she joins.
Am I audible?
Prachi, you are audible.
Am I audible? Okay.
Prachi, I think you should switch off your video.
Okay. Okay, fine. The team speaking against the motion comprises of Ms. Kirti Singh, Mr. Anurendranath, and Ms. Anubha Rastogi. Ms. Kirti Singh is an advocate who has been working on issues of women's rights and human rights for the past 35 years. She was a part-time member of the 18th Law Commission of India and has worked on reports recommending legal reforms to laws regarding women and children. As part of the women's movement in India from the beginning of her career and as a legal convener of AIDWA, she has fought cases relating to women and children and has initiated and advised on legal reforms in laws impacting women and children in India. She has appeared in a number of public interest litigation cases in the Supreme Court of India, challenging the constitutional validity of discriminatory and unjust laws, including a challenge to the Haryana Panchayati Raj Act, which excluded a large number of citizens from contesting elections on the grounds of lack of educational qualifications. In the Law Commission, she worked on reports relating to child marriage in India and the introduction of new criminal laws to recognize acid attacks as a specific gender-based crime. Through the years, she has drafted comprehensive proposals to change the laws relating to maintenance laws and adult and child sexual assaults in the Indian Penal Code and in other related laws. She has more recently also prepared a bill which seeks to punish crimes in the name of honor, which has also been adopted by the National Commission for Women. She has also researched and written extensively on various topics, including laws related to a non-preference for the UNFPA, and a book on the economic rights and entitlements of separated divorced women in India. She extensively writes articles that are published in Indian and international books and journals, such as Health and Human Rights Journal of Harvard University. She has also been a fellow to the Center for Human Rights and Legal Pluralism at the Law Faculty, McGill University, Montreal, Canada. The second speaker is Mr. Anup Surendranath. Mr. Anup Surendranath is an assistant professor of law and executive director of Project 39A at National Law University, Delhi. Project 39A is a criminal justice program that undertakes multidisciplinary research on forensics, mental health, and criminal justice, torture and legal aid, and the death penalty. Project 39A also undertakes pro bono legal representation as part of its legal aid mandate and has been involved in representing nearly 130 prisoners sentenced to death. Educated at Nalsa University of Law, Hyderabad, and the University of Oxford, Dr. Surendranath is also on the advisory council of the Bonavero Institute of Human Rights at the University of Oxford. The third speaker in the team consists of Ms. Anubha Rastogi. She is a litigating lawyer who has been litigating for the past 17 years. Originally from Bombay, she studied law from Law Center 1, Faculty of Law, Delhi University, and started her practice at the Chambers of Law under Advocate Anupam Srivastav, who taught her various intricacies of civil litigation. She then worked with the Women's Justice Initiative of the Human Rights Law Network, where she assisted women from different walks of life to access justice and also represented issues in public interest litigation. She has also worked closely with a global software company to ensure that the workplace was free from harassment and discrimination. She worked at the Center for Equity Studies and was part of a legal audit done of the state response in 7 specific post-partition communal massacres in India. She led the team representing the Dalit community in the Mirchpur trial, sentences for the convicts and conviction for most of the acquittals. She is actively involved on issues pertaining to sexual and reproductive health and rights, and has authored Assessing the Judiciary's Role in Access to Abortion in India, published by Pratigya Campaign for Gender Equality and Safe Abortion. She is based in Bombay and is also a special prosecutor for SEBI. Before we move on, I forgot to mention one thing in the structure of the debate. When there are 2 minutes left, Soumya or I will interject and tell the speaker that 2 minutes are left. Thereafter, when 1 minute is left, we will interject and inform the speaker that 1 minute is left. And when 30 seconds are left, we will interject and inform the speaker that 30 seconds are left.
Now I open the floor for the debate and invite Ms. Geeta Luthra to present her views. Geeta ma'am, over to you.
So, dear friends, fellow colleagues who are on my side of the debate and those who are against me, and all friends who are listening to us, good evening. Death, the word, has a finality. It's a full stop. It puts to end any debate. For this reason alone, I say that speaking for the motion, once it has finality, the debate should be, and the arguments are in favor of death penalty. Now, my first aspect is the historical perspective. Originally, death penalty, or any penalty for that matter, had to be associated with the theory of criminology. Initially, justice was supposed to be retributive. Then came the theory of deterrence. Then came the aspect of reformation, reformative, and finally, rehabilitation. If we are talking of retributive justice, it has always been eye for an eye. if we are talking of deterrence, then I would say that this is what is the more prevalent view in today's criminal justice system. And I will show why I believe that deterrence cannot be an answer. And deterrence is a misplaced theory which should not have any place in the criminal justice system. The last is reform. And if we have to just visit one of the best jails in our country, walk into Tihar jail, and you would see why justice cannot, in today's day and age, think that criminal law is reformative. Walk into a juvenile justice home and see that criminal law does not see justice as reformative or as rehabilitative. It may be the way for the future. It may be something which we can look at in an idealist society. But we are today in India of 2020. In India today, if we go into Tihar jail, which perhaps is one of the finest jails we have, we will see that there is no element or hardly any element of reform. If we look at the juvenile justice homes, we see that those who are young people who have given into crime and those who are without homes, all of them are bundled together. What is the element of having psychiatrists, sociologists, social workers, psychiatrists, counselors be there to rehabilitate them, to establish them as members of society, to do a reformative justice? Our justice is not reformative. Now, coming to deterrence, who do you want to deter? I ask myself this question: who do we want to deter? Do I want to deter the next person who is accused in another case? Can I be giving a punishment to A so that B doesn't do anything? I have to punish A for what A has done. I cannot punish A so that B doesn't do anything in future. Justice has to be for the person that has committed the crime. Justice cannot be in a future perspective, looking at what another man may do. Because today's perspective may be different from tomorrow's perspective. Therefore, justice and a theory of deterrence is highly misplaced, highly illogical. And that is why I say, therefore, you come back to a theory of retributive justice. This does not still mean eye for eye. It means just that, justice. Therefore, mercy for an accused should at the same time be balanced with mercy for the victim. Nirbhay's mother would not feel good if she felt that the 4 people are not being given death penalty because that it is not to be retributive. They were first-time offenders. It was the first case of the kind. They were not repeat offenders. There was no recidivism in their cases. Yet they were given death penalty. For me to tell Nirbhay's mother and to tell society that, look, let us give only life imprisonment and not death penalty because we should be merciful and we should hope for reform and rehabilitation, was not an argument that was countenanced even by the courts or by anyone. That is why justice has to not only be merciful, firstly, it has to be merciful to the victim, the family, and the society. And then it has to be seen to be merciful to the accused. It is a misplaced sense if we say that we have to show mercy to the accused. I begin with this with a quote from none other than Dame Agatha Christie. Mercy detached from justice grows unmerciful. Too much mercy often results in further crimes which are fatal to victims who need not have been victims of if justice had been put first and mercy put second. There is a very strange argument, two strange arguments that I want to look at. One, that death penalty is not reversible, and that is why there may be incorrect cases. How many cases in our perspective, in our historical perspective, in our empirical evidence have we set aside, saying after 10 years, no, this was not a case of death penalty? I don't see any. So let's see, therefore, this argument that justice should be, requires that it cannot be reversed, cannot be an argument. The argument then should be, let us be careful. Let our investigative tools be so good, so fair, so just that we ensure that we do not convict a wrong person. As we say, 99 accused should go scot-free, but one 99 guilty may go scot-free, but one innocent should not be convicted. Let us improve our criminal justice system. Let's improve our investigative system. Let's have a higher rate of conviction. In India, as today, 42% rate of conviction for other cases, 28% conviction rate of rape cases. This is a poor rate because your evidence is so poor, your investigation is so poor, is unscientific. That cannot be a reason not to have death penalty. On the other hand, it's a reason to have death penalty because you have to have what will ensure law and order. Look at the countries of the Middle East. Look at some of the Southeast Asia countries. Look at the fact that the law and order is better than in India. And we have such a vast criminal justice system. And one of the reasons is the fact is that their punishment is so lethal that anyone is scared. Why are we insisting that the punishment for rape should be increased? What about terrorist crime where thousands are killed at the hands of a misplaced human being? You cannot be thinking only in terms of reform. And look at the trend of the Supreme Court. You had no convictions for a long time of death penalty. And look at from 2000 till now, you've had 60 cases of death where people have had death penalty. Why? The reason is that justice should be more sure. That is the only way that you will have better law and order. You will have better respect for the laws. Ultimately, the criminal justice system has examined it. The Law Commission has examined it, not once, not twice, thrice. It examined it in the 35th report. Firstly, the Constituent Assembly examined it. There were debates and debates, and there was a fear of misuse. But the fear of misuse has to be taken care of by having a better investigation, a more scientific investigation. And then we had the 187th report, which was with regard to modes of execution. Again, death penalty was indirectly held to be upheld when it was looking at modes of execution. Then we had the 262nd report by none other than a chairman like Justice A.P. Shah, one of the most liberal judges and heads of law commission. So repeatedly we have said death penalty should be retained. It should be retained in terrorist crime. It should be retained in heinous murder cases, but you look at the criminal, not the crime. The last aspect which I want to point out, that in Bachi as well as in in Bachan Singh as well as in Machi, what the Supreme Court seems to say is collective conscience of the people. What is collective conscience? Collective conscience is Twitter? Is it social media? What is collective conscience? I am for justice, and death penalty has to be given where the justice demands it, not where collective conscience. This is one aspect which I would want to be given up. But the fact is that till we have a better rate of conviction, till we are more sure about what is the rate, we have to ensure that conviction, sure, death penalty's finality will be better. There is a last argument. I believe that if life were to be life till one dies, then many people would prefer death. It is better to be dead than to be a living dead. In all these aspects, I say, death penalty is an answer, though it has to be prescribed in a very circumspect manner, surely for those offenses, heinous offenses, where it is necessary and not more than it's required. Similarly, as the Criminal Procedure Code has made that amendment in 354 subclause 3 of the Criminal Procedure.
Now,
Ma'am, I'm sorry, the time is...
Thank you.
Thank you so much, ma'am. Thank you so much.
Thank you so much. Thank you.
Can you have a slightly louder pip so that we can hear? I was prompted by my office, otherwise I wouldn't have known.
Sure, ma'am. We'll keep that in mind.
Keep that in mind.
Thank you.
Now, Ms. Kirti Singh will open the debate against the motion.
Yeah, can you hear me now? Dear friends and colleagues, I speak against the death penalty because I believe not only that it is cruel and inhuman, but it is often arbitrarily given and is unreasonable. The UN disapproves of death penalty and is an active advocate for its abolition. As recently as this week, the UN General Assembly voted overwhelmingly for a moratorium on death penalty, India being a notable exception. According to the Amnesty International report of 2019, 146 countries have done away with death penalty in law and practice, while 106 have retained it. I'm making 4 major arguments to support my case. First, I will oppose death penalty on moral grounds. Second, I will show that, contrary to popular belief, it is not an effective deterrent. Third, I will show that fallible criminal justice system or systems such as ours should not be awarding death penalty because it can never be awarded in a truly fair and standardized manner. Finally, I will argue that the irrevocability of this punishment makes it impossible for the state to correct its mistake in meting out this punishment. Now, coming to my first argument, in Francis Corelli's case, the Supreme Court held that Article 21 gives protection from torture or cruel and inhuman treatment and punishment. In fact, many prominent philosophers have exposed or opposed death penalty on grounds that it is immoral and that it is cruel. Firstly, thinkers have pointed out that criminal alone should not bear the responsibility of the crime he commits. The father of our nation, Gandhiji, argued that the criminal should be seen as a deceased person uh, who the society must take responsibility to cure. Albert Camus reasoned that civil society as a whole is responsible for crimes and talked of the role of a state in creating poverty, homelessness, unemployment, amongst other disparities. The late K. Balagopal advocate too once remarked, capital punishment does moral wrong by imputing to the offender the full individual responsibility for the offense, ignoring the contribution of circumstances, more particularly social circumstances, and places the totality of the moral guilt on the offender, which is never fair, even in extreme cases. Vinoba Bhave and Jay Prakash Narayan have also opposed the death penalty, for they were advocates for reformation. Any moral justice system views the reformation of criminals as its responsibility. Vinoba Bhave believed that the human being can be reformed and, in fact, managed to make Chambal dacoits surrender and give up their violent ways and their arms. Andrei Sakharov famously said that savagery only begets savagery. The humanness of society, in fact, goes down with state-sanctioned violence. In this context, I will say that death penalty serves no purpose which cannot be served by a life sentence and commits the additional moral wrong of allowing the state to take a life. This brings me to my second argument. Many argue that death penalty is a useful deterrent against heinous crimes. In fact, there are a gamut of empirical studies that disprove this theory. And the National Academy of Sciences in the US showed that there was no conclusive evidence that it is a deterrent. In India, our own experience shows that even though death penalty was introduced for child rape, rapes have continued, and the figures for rape are higher in 2019 than in 2018, according to the NCRB, when death penalty was introduced. Even the Law Commission report, in its the 252nd report, has said that death penalty does not serve the penological goal of deterrence any more than life imprisonment. Cesare Beccaria, in as early as the 18th century, pointed out that deterrence is better achieved through the certainty of punishment and not its severity. This is why women's organizations and groups in India have fought for prompt FIRs and better investigation and prosecution rather than harsher and harsher punishments. And they are opposing the death penalty for child rape, and they are opposing a death penalty being introduced for acid attacks and for all sorts of murders in Maharashtra. Fallible investigation is the second point. Third argument, rather. I have some experience of working of the criminal justice system, just as you all have. Working specifically in the field of human rights and women's rights, I have seen how the criminal justice system is fraught with inefficiency, bias, and corruption. The impact of the criminal justice system is felt acutely by the poor and the marginalized. It is they who constitute the majority of death row victims. As Justice Bhagwati observed in the dissenting judgment in Bachan Singh, and I quote, "Our methods of investigation are crude and archaic. Our convictions are based largely on oral evidence of witnesses. Often witnesses perjure themselves as they are motivated by caste, communal, and factional considerations. Sometimes they are even set up by the police to prove that what the police believe is the true case Faulty investigation is thus widespread. The Delhi riots, for instance, show us how inefficient and biased a police probe can be. Long delays in obtaining justice and long periods of incarceration in jail on death row amount to infliction of psychological punishment too, and psychological torture. Another important aspect of the fallibility of the criminal justice system is its reliance on judges who themselves are human beings and are therefore subject to human limitations. We have seen that judges have their own judicial philosophies, which tend to guide them. The Supreme Court has pointed this out in a few of its decisions. In the 2000 Swami Shraddhanand case, for example, the Supreme Court itself admitted, and I quote, "The truth of the matter is that the question of death penalty is not free from the subjective element. And the confirmation of death sentence or its commutation by this court depends
there are 2 minutes left.
Okay, on the personal predilection of the judges constituting the bench, the inability of the criminal justice system to deal with all major crimes equally effectively, and the want of uniformity in the sentencing process leads to a marked imbalance in the end results. The law is meant to be certain. However, we've seen in the Dhananjay case and the Kumudi Lal case how Dhananjay was awarded the death penalty, but Kumudi Lal wasn't. We have seen how Bilkis Bano, in Bilkis Bano's case, the accused were not awarded death penalty, but in the Nirbhaya murder case, they were. So death penalty is unevenly given, it's arbitrary. The point about irrevocability is that after the eviction of Dhananjay Chatterjee, evidence of PUDR, for instance, came to light, showing that the evidence relied upon was less than reliable and extremely controversial. Similarly, in the Malgaon blast case, 9 young boys were put on death row and incarcerated for 10 years, after which
1 minute left.
they were freed. Death penalty is irreversible. The cruel and cold finality of it makes it qualitatively different from all other forms of punishment. If a person is found innocent and if he is given death penalty, there is no going back on it. The Evans case in England, where an innocent man was hung, in fact, played a significant role in abolition of death capital punishment in England in 1965, as in Belgium. In India, we have several instances of capital punishment where the evidence has been less than conclusive. Death penalty is therefore unacceptable in both theory and practice, and the march towards civilization must include a march for abolition of death penalty. Thank you.
Ma'am, the time is concluded.
Yes.
Thank you so much.
Thank you so much.
No, thank you so much, ma'am, for your views. Now, Ms. Shweta Kapoor will present her views as the second speaker of the team in favor of the motion. Ms. Shweta Kapoor, the floor is yours.
Thank you. Thank you, Kirti ma'am. Thank you, Geeta ma'am. I will be taking a little bit from both of them and continuing with the same arguments, but probably slightly from a different standpoint, because the way we all decided and prepared our debate was that I will be touching on the sociological perspectives more than the legal perspectives, because legally these people have a lot more knowledge than me. So that's how. I would actually want to begin with the fact that already internationally speaking, our country is one of those countries which does not have death penalty for very many cases. We have death penalty only for a limited number of cases. So we are not really a trigger happy country where we are handing out death penalty for all kinds of cases. So we already know that it is triable by the sessions. It's a serious offense. So the trial anyway begins at a senior court, and rather than beginning at the level. One is that. Then the other thing is that once we have categorized the number of or the kinds of cases which are going to get death penalty, there is a different kind of a system under the CRPC, which is there by which our criminal justice system moves. So essentially, we have something very well entrenched in the system, which is called as a rule of law, the due process of law. Internationally speaking, everywhere, everything completely boils down to the process of law, and India as a country is following it to the spirit. We are following everything which is there in the book. Now what we essentially need to understand is that if everything is happening as per the system, then why are we are having this debate at all? So I think for doing this, we should go a little behind the scene, and let's discuss a little bit. I want to touch upon on the cases that have already been decided and which are famously in public domain. And since these cases are not sub judice, I think I can take the liberty of discussing them in a limited manner. I want to actually begin with one of the cases which actually can run shivers down anybody's spine. It's an old case. It's a case of Miss Aruna Schonberg. This was one of the cases where one man had raped a woman. He did not kill her. He strangulated her to the impact that left on her was that the oxygen supply was cut from her brain and she was reduced to a vegetable for the rest of her life. Now, at that point of time, we did not have this amendment in the IPC that has happened later, that if you rape somebody and leave them in a vegetative state, then death penalty can be granted to you. So now this is something that has happened after reform in the Indian Penal Code. This has come because Indian criminal justice system is not static, because we have evolved as a society, implications and the kind of crimes that can be committed. So this is now there. But what had happened at that time was that a very limited punishment which was available for rape was handed out to that man. And after a few years, he completed his punishment and he was out. He is married, he's living a normal life. So what are we talking about? The woman who was the victim, the one who should have got justice, did not get any justice according to me. She was reduced to vegetable and she died in the same hospital on the same bed after many, many years. And we famously have the case filed by the hospital where they wanted to give her mercy killing, but it was not allowed by the Supreme Court at that point of time. That is another aspect. Now, coming down to the second popular case, which also is a case from Delhi, which actually began the rape debate probably, which is the case of Billa and Ranga. Now, this is a particular case which I'm actually discussing because these two people were executed finally. And why this case is important is because in somewhere the jail memos of the superintendent of jail, he had very clearly written that when he interviewed these two criminals over a period of time when they were spending the time in jail, every time he asked them, were they guilty? The answer he got was Ranga Khush. This man never ever said that he had done anything wrong. He never agreed that he was guilty. He did not say that he wanted to be reformed. Are we talking about people like these who we want to reform? I don't think so. These people are beyond reform. There are several studies in the US, there are several studies in Europe. In Singapore, you'll find them. There are statistics galore of people who have killed innocent people, who have raped and murdered victims at will, at whim. They just wanted to do it and they did it. So we are actually essentially trying to deter such kind of people. Now, of course, deterrence is a word I don't want to use right now because it is not exactly
2 minutes remain.
proved with statistics. So we cannot use that word right now, but let's come down to the next aspect. After discussing this mixed bag of cases, there are other cases. For example, there are the Nithari killings, where also the crime has happened.
You are inaudible. Your screen has frozen.
These facts. So these people come from a mixed bag of society. They're higher, they're lower, they're placed everywhere.
Your screen had frozen for a bit. Could you just go back 30 seconds in time and speak again?
Okay. Okay. I was basically saying that if we look at the kinds of people we are talking about here who were convicted or who were accused are a mixed bag of society. These people come from various sections of the society, and they are not necessarily people who were not rich or who came from middle class. They are somewhere rich, they are somewhere placed in the middle of the strata. So demographically, they are a mixed bag. So we cannot essentially say that these were people who did not have access to the justice system. They did not have access to good lawyers and all of these things, which are normally used as, let's say, reasons for the kind of why there should not be very harsh punishments for people who are being tried for
1
death.
minute.
Okay, so finally we come down to the system of retribution. Now, why are we talking about retribution and why are we repeatedly talking about it? Is because everybody in a democracy or in a society is very dependent on the state. They look at the state for justice. They look at the state to mete out some retribution to them, because they cannot go on and do it. We cannot have a society which is trigger happy. We live in a country where there are female infanticides, there are female feticides, there are honor killings. These are all conscious killings which are happening every day. So since we cannot avenge all of this, and we cannot have everybody looking at these things and taking a revenge on their own, the state has to step in. The state has to look like it is going to give justice to the people. To establish a humane, equitable, and just society, it is important
The time is up.
highest deterrent punishment possible. And that is why I am in favor of it. Even if we don't give it, we'd better have it in the books at least. Thank you.
I now request Dr. Anup to speak against the motion. Dr. Anup?
Right. Can I be heard? Hello? Can I be heard?
Yes. You are audible.
Yeah, all right. Thank you. Thank you so much for having me here, and also to all the speakers before me. And I'll try to respond to some of those arguments and put mine forth as well. I want to basically look at 4 points during the course of my 7 minutes. I want to understand and present to you who gets the death penalty and how do they get it. And in terms of, do we really follow the law, and the question of, can we really follow the law? The second is the question of reformation. Ms. Kapoor said whoever these people might be, cannot be reformed, and I want to comment on that. And I want to bring to you what is actually the suffering of the death penalty, and when we say it's cruel and inhuman, what is the actual suffering of the death penalty? And lastly, I want to reflect on the arbitrary application in the jurisprudence of the Indian Supreme Court. In terms of who gets the death penalty, I disagree with Ms. Kapoor that this is a mixed bag. It is not a mixed bag, right? Our empirical evidence with interviews over all of India's death row prisoners show that nearly 75% of India's death row prisoners are poor, and that should not surprise us, because that is the reality of the death penalty in all the countries across the globe that retain the death penalty. In later stages of the death penalty that Ms. Kapoor outlined, be it at the Supreme Court stage or at the mercy stage, 42% of death row prisoners belong to scheduled caste and scheduled tribes categories, which is far in excess of their proportion in the population. So there is a very clear pattern here that it is the most marginalized and the most poor in our society that get the death penalty, and that is a global phenomenon. It's not something unique to India, right? And that is the burden of the death penalty, that it has a disparate impact on the most marginalized. And this translates into very serious rule of law implications. 97% of India's death row prisoners did not have a lawyer at the time of their interrogation. 90% didn't have a lawyer at the time of their first production. And nearly 80% of them, their lawyers never discuss their cases. And that's not surprising, because these are very poor people who can't afford good legal representation. They get terrible legal representation. And even in the trial court, even though they have private legal aid, most of them, and it is a situation that then gets inverted in the High Court and in the Supreme Court, they have terrible legal representation. And that is why you don't see lawyers sitting and discussing these cases and presenting those version of those facts. And the problems with these cases emerge much later on. Ms. Kapoor referred to the Nithari case. I mean, and it is a fantastic example of all that can go wrong with the death penalty and the role of the accused in that case. And the manner in which the confession is extracted in that case And the video of the narco analysis in that case is something that's worth seeing. And it shows how our criminal justice system is completely broken. The reality of our criminal justice system is that that there is a massive prevalence of torture at one end of the spectrum, and at the other end, it is also true that survivors and victims of crimes really find it difficult to get justice. Both of these are realities, and there is no point trying to say that we can get better victims, we can get better justice for victims by taking away more and more and more rights of the accused, because both are problems that require their own set of solutions. Ms. Kapoor also said that and laid out the legal process and the structure through which we carry out, and seem to believe that there is a certain rule of law that we follow, and therefore it's all great. But that's not true. Bachan Singh said that there has to be a certain sentencing exercise that has to be carried out, that you weigh aggravating and mitigating factors. But please, any honest look at these cases and the manner in which these cases are conducted will show you how pathetic sentencing is in Indian courts, right? And that is not surprising because of the nature of the prisoners that we're talking about and the kind of legal representation that they get. There is hardly any mitigation information that is brought into courts for judges to consider, right? And mitigation information is not just saying, oh, this person is poor, has two, they have two family members. Mitigation information and mitigation investigation are meant to be a detailed investigation into the lives of the accused that starts for the courts, that then courts and sentencing judges can then begin to understand who are these people before us. And that is a question. If you read death penalty judgments, either commuting judgments or confirming judgments, you will see how lawyers are just not putting forth that information. And it's not surprising. It is not surprising because that takes a lot of expertise. It is not about just one interview in some godforsaken mulaqat room for 30 minutes that everybody will pour out the story of their lives to you, right? It takes a lot of expertise. It takes social workers. It takes mental health workers, right? And how to present that information is expensive. It is a job of experts to do. Lawyers alone cannot do it. And now my point is, if you're so serious about wanting to take someone's life as a system, we must also invest in these processes, right? If you are so wedded
So there
to
are
the
2
rule
minutes
of law,
left.
yeah, thank you. If you are so wedded to the rule of law, this is what we must do, right? Reformation is one of the requirements that the law requires to take, that the state has to show, as per Bachan Singh, that the prisoner before the court cannot be reformed. And we have barely ever see any information about the conduct of the accused in prison coming before the judges, right? And if you look at the discriminatory treatment meted out to death row prisoners as a category of prisoners in Indian prisons, much less is said the better about that. The suffering of the death penalty, I think, is often misunderstood as that point of killing, right? The manner in which Indian death row prisoners are kept, they are kept in gallows, in barracks that always have a view of the gallows, right? Their lights are switched on for the entirety of the night, right? They are not allowed to meet others. They are denied all sorts of opportunities. And it is a daily anticipation of death, of not knowing whether you're going to live or die. That is the true suffering of the death penalty. And that is the cruelty that we as a society choose to inflict. On arbitrary application of the death penalty,
Time is up.
yeah, I only have one thing to say. You just need to compare the judgments of Arijit Pasayat and S.B. Sinha, and you will see how the kind of subjectivity that rules death penalty sentencing in India. Thank you.
Thank you so much, Dr. Surendranath. Now, the last speaker for the other side is Ms. Kritika. So, Ms. Kritika Gupta, if you could, the floor is yours.
Thank you, Prachi ma'am. Good evening, one and all. Before addressing this virtual gathering, I would like to thank the Delhi High Court Women Lawyers Forum for giving this unique opportunity to us to have this academic discussion. Enough has been said about the death penalty, its deterrence. Geeta ma'am had so beautifully put that deterrence is maybe the wrong question that we are asking us. Dr. Surendranath has just said, and we all know the Project 39A report, where such a comprehensive study was done for the first time as to who are these people who are on the death row in our country. But as a young citizen, I do want to ask all of you and myself, has any comprehensive study ever been done as to who are the people, who are the victims of these crimes? The irreversibility of death penalty is for the criminal is as much as for the victim too. We somewhere, in my humble opinion, romanticizing the idea of the rights of the accused. This complete dystopian idea that the criminal justice system is failing around us all around. And so are we heading towards a world where we do not need a rule of law? Do we not need to give any punishment? For this, I want to present the first argument that since so much has been discussed about the penological efficacy of various punishments, looking at the trends and the data, limited data, which is available in the Indian context, is any punishment by that measure proving to be a deterrent in our country? So, what happens in a world where you do not give the death penalty, where no crime deserves the harshest punishment of the land? You imprison people. More and more people are imprisoned. In this context, I would like to all of you to look at the prison statistics which are published by the NCRB. Let me caution you all here, not even for a single minute am I making that crude and tone-deaf argument that since we cannot keep people in jail, so let us go hang them. Not at all. The argument I'm trying to make here is that the touchstone on which we are testing the efficacy, whether it's in the form of deterrence, reformation, or even rehabilitation, and now in the 21st century, reintegration of the criminal in the society back. Every sort of punishment by the touchstone which is being sought to be applied here would fail its very purpose. So let us, I would say that look at the problems with our prisons. Our prisons are overcrowded. We have prison management issues. There is complete lack of medical assistance. There is no education regime to rehabilitate these prisoners. The prison suicide in India is steadily increasing since 2016. And India also has a very unique issue, which is of jailbreak. We just saw in February 2020 that there were 4 inmates of the Amritsar Central Jail which scaled the walls of the prison and just escaped. And more than 7 police officials were suspended because of it. So what do we do in a situation like this? Should we just stop giving any sort of punishment, howsoever severe or mild? Should we just do away with the rule of law and wish away all our problems? I do agree with Dr. Surendranath that we need better criminal investigation practices. But it does not for a minute mean that we have to do away with the punishment which are given to a criminal in our country. There is also another unique problem that India is facing now. Like Geeta ma'am had touched upon, the recidivism problem. For the uninitiated in criminal law like me, it means the rate at which repeat offenders come to light or repeat offenses take place. In India, that rate, albeit small right now of 8.6%, has been steadily increasing. What does this show? Again, that our prisons are completely failing in its exercise of being an institution of reformation and rehabilitation. So when there is, the point I'm trying to make here for this gathering is that while there is no empirical data which shows whether the death penalty is ineffective, we have data that the other forms of punishment are ineffective. With this thought, I would like to leave you all that we need to ask a deeper question as to how and what and in what manner the punishment is to be given. Since so much has also been talked about, I would also like to present some international data in the debate for death penalty. Let us look at Singapore. Look at the country Singapore. It is lauded for its very low crime rate. And in the World Economic Forum's list of 20 most safest countries in the world, it comes only second to Finland. Now, the unique feature about Singapore is that it hands out the death penalty even for crimes like drug-related crimes, firearms, not just the murders. And it was the biggest opponent of the second optional protocol of ICCPR, where UN wanted to make the death penalty abolishment compulsory for all its members. Yet, the criminal justice system of Singapore and the country is lauded as a model state for one and all across the world. There is hardly, if you look at the public discourse in Singapore, there's hardly any discussion of abolishing the death penalty. People of Singapore want it, and the government has been listening to them. And in a manner, Singapore hands out the maximum number of death penalty per capita. I would also like to take the example of Japan. Just on 15 December, they have handed out the death penalty to someone called the Twitter killer, who had killed some around 19 people by just by calling them on Twitter and on various social media, and then dismembering his victims when he used to meet them. Again, that country has the lowest murder rate, and there is hardly any debate whether or not there should be death penalty. Take the example of Venezuela right now. It was in 1863 the first country in the world which, by an act of parliament, abolished the death penalty. And right now, it is suffering from the highest crime rate in the world. South Africa, which a lot of us feel is an example a lot close home, they did do away with the death penalty in 1995 by a decision of the Constitutional Court. But as of now, the violent crime, it's a documented fact that violent crime is on the increase in South Africa.
1 minute remains.
Thank you. And public has been clamoring in the 2019 elections, which just happened in South Africa. There was a public demand for the death penalty to be revived, which I would now, due to paucity of time, like to bring to the last question. Nobody here is arguing for mob mentality, but India, as a young democracy, the legislature, the executive, and the judiciary owe a responsibility to its people to take forward its aspirations, its right, and the various aspirations of the citizens. In this context, to say we also have to balance the competing rights of the victim as well as the citizens. We have to establish the rule of law. And rule of law for whom? The law-abiding citizens of the country, who look up to the country that they will be protected and they will be allowed to live in a safe and crime-free zone. With this, I would like to wrap up my submission. Thank you.
Wrap it up just in time, Kritika. Thank you.
Thank you.
Ms. Anubha, I request you to take over the floor and conclude this debate.
Thank you so much. Hopefully, I will also be just in time. So let me just begin my conclusion in a sense by saying that where I stand, I'm quite clear that the state can never be given the power to take away someone's life. But having said that, of course, I'm absolutely, I do know that the Constitution and the criminal law does permit it. It has been held to be constitutional. But when I look at this debate from the point of view of the Universal Declaration of Human Rights and the fact that human rights are infallible, and especially the right to life, then where we keep insisting that the state can, in some processes, be given the power to take away someone's life is in itself contradictory. Let me now just move on a little bit to what is it that one, as a citizen, as a person staying in a place, expects from the state, especially when you're dealing with the criminal justice system. What one expects is that if something wrong happens to me, there is certainty of justice, there is certainty of punishment. I don't expect that it has to be the most severe thing, but what I do hope and pray is that I will get justice. There will be some punishment for a wrong act if it has been done on me, and it has been proved by rule of law, by the process, that yes, this person is the one who has actually committed that act. And what does that really mean? That means that if at any point in time something happens, I'm certain that when I do speak to the stakeholder, or in this case is usually the police, that when I speak to the police, there will be a respectful discussion that will take place. They will take down what I'm saying and lodge an FIR, do an investigation, a timely investigation, a proper investigation. This is what I mean when I say that there will be certainty, that when the investigation is done with everything that is available, the scientific technologies, whatever else is available, forensic technologies are available, all of that is utilized to ensure that whatever investigation is required to be done in the facts of the case is being done. There is timely movement of the matter. The courts are available. The courts are friendly. The courts are also balancing the rights of the survivor or the victim family and the accused, and that there is a respectful behavior. If especially in the case of a rape survivor, that she is being treated, or he, if it's a male who has been raped, or a transgender person, that the survivor is being treated as respectfully as possible, by ensuring that whatever is required to make the ends of justice meet, that is taken from her or him, and the case is forwarded. With that, when we say that there is certainty of justice and certainty of punishment, that is what one means. But what really happens? And let me also just bring in the second aspect, which has been spoken about quite a bit, that the state, that we look up to the state to take revenge, to do correct the wrong that has been done to me. But let me just remind everyone here who's listening and who's also spoken before, that what is the role of the state? And when an offense occurs, it is the state which has failed twice, because it has permitted an offense to occur and a victim, to a person to become a victim. And also it has failed the accused, because it has not been able to prevent the occurrence of an offense. Let me just lay that down very, very clearly. The state is in the business of ensuring that everyone is following the rule of law. And to ensure that, it has to ensure that the systems are in place, that there are proper procedures, proper mechanisms. For example, if there is a woman who is walking a street and there is no street light, it is the state's responsibility, isn't it? I mean, we've all studied this in law, that the state had to even pay compensation because it did not prevent a rape from taking place in its in a public place, the railway station. So therefore, it's the state which is failing twice. And in this, the state cannot now take sides and say that, okay, now I'm going to avenge what has happened to the victim. Because it has happened because the state has failed in fulfilling its
There are 2
duty.
minutes left.
Thank you. So as far as, offenses, especially on the body of a person, mostly a woman, mostly a child, take place, this is definitely something that I would push for, that the state cannot be in the business of taking revenge. And also, if we just notice what has been happening, the moment there is a public outrage, the state comes up with this solution that, okay, you know what, I'm going to make it, I'm going to increase the punishment, and I'm going to bring in death penalty for rape and murder. Then a few years go past, and there is a public outrage for another offense that the state was not able to prevent. And this time it's a girl who's below 12. So then the state says, okay, fine, you know what I'm going to do now? I'm going to amend the existing law, and I'm going to say that now there will be definite death penalty for any sexual assault of a minor who's below 12 years. But what has happened between those two intervening periods, where the state was expected to ensure that, okay, fine, while the death penalty is existing on the statute book, but as the state, as the government, I have ensured that this will not happen again. It's not enough for the state to say that I'm saying that this will not happen again because there is death penalty, because that really doesn't work. I mean, even people...
30 seconds left.
I'm sorry?
30 seconds.
30 seconds, thank you. And very quickly, because I have very little time now, I also want to bring in the aspect of terrorism, because always a lot is said about the fact that, okay, there is rape, and then are you going to even not advocate death penalty for people who are accused and proved convicted of terrorism? And I'm just going to very quickly read what the earlier UN General Secretary, Mr. Ban Ki-moon, had said, that experience has shown that putting terrorists to death serves as propaganda for their movements by creating perceived martyrs and making their recruiting campaigns more effective. Frankly, we really need to see. I mean, I sit in Bombay here. We've had the 26/11.
Time is over. I'm so sorry.
Thank you. It's just. I invite everyone to just see what kind of systemic changes were brought in by the state government here to ensure that the 26/11 doesn't take place again. And I can tell you, nothing much. Thank you.
Thank you everyone for such an invigorating and exciting session. In the event that either of the teams want to ask a question to the other team, we open the floor before audience questions for the teams to ask each other questions. So would anyone like to ask the opposite side a question?
I think we are both all convinced of each other's arguments too much.
Okay. All right, then we'll open the floor for audience questions.
I now open the floor for audience questions. Tanmay, would you like to ask your question? Mr. Tanmay Yadav?
Yes, ma'am. Good evening. Good evening, everyone. My question is to Anup, sir. While I understand what arguments have been raised, mostly I understand that the issue is that mostly it is a lower income group and the weaker section of the society, which is at the receiving end of this entire death punishment issue. My question is, are we to understand that by improving the aspects which have been mentioned by you for abolishing it, if we improve on that, death punishment is justified? This is my question. Thank you.
Right. Do I answer it now, or should I? Soumya, should I answer the question?
Please go ahead and answer.
Yeah. Thanks, Tanmay, for that interesting question, and almost always the most challenging question. That what if we change this? Can we reform this? And if we reform this, then are you saying that the death penalty is justified? I think the argument is on both counts, that there is a in principle objection to the death penalty that Ms. Singh and Ms. Rastogi have made, that there is an in principle objection to it as well. But in addition to that, there is also a systems reality argument to this, right? How is the death penalty, even if we have it, how is it being used? And I was elucidating on that. But then to a broader point, I would say that, the kind of problems that we are talking about, right? The disparate impact, the kind of investigations and the kind of legal processes that we're talking about are so endemic to our criminal justice system that while we can theoretically entertain the possibility that, all of this can be set right and, we will have a perfectly just and fair criminal justice system, that is not really in the realm of possibility, right? While we can theoretically consider that, sure, but my argument is also that on the question of whether we should abolish it in India, we also have to take into account the realities of the criminal justice system. And these things are so fundamentally entrenched in our criminal justice system. I really don't see any reasonable time frame. And the question is, why should then some people keep paying the price for what is necessarily an unjust criminal justice system, right? And I think nothing is too early in that sense to do away with it, right? And you might say, and the argument might be then, what about, are you saying then we shouldn't have any punishment at all, right? Because this would be true as much of any other punishment. But I think that's the question, that's the balance, right? Do we want to take life on the basis of such an unfair system?
Well, thank you, sir. Thank you.
Thanks, Tanmay.
I don't know how I got muted again. Am I audible?
Yes, you're audible.
All right. So there's been one small glitch from our end. When we meant that the teams could ask each other questions, we also suppose that if any team wants to rebut an argument of the other team, they would have the time for that. So if in case there is anybody who wants to rebut, I would request you to keep it very short. Just unmute yourself and rebut the argument of your opponent. Please go ahead. Anubha,
you want to go?
Yes, Anubha, you wanted to rebut, so please go ahead.
Anubha can't rebut. She was the last. She's already rebutted.
I was in fact asking for our side and for for everyone's side, not just
rebut. She is already rebutted. So rebut I can do because I was the first speaker. or Kirti can do, who was the first speaker for the other side. But Anuba has already answered everything.
Absolutely, ma'am. Please go ahead. I was asking for everyone, for all the panelists, whether there is a
One member
rebuttal or
of
not.
each
The
team.
others get a chance. I was just speaking on the lighter side. Let everybody else go on. And if I have to say anything,
I think that is a very valid suggestion from ma'am in view of the time also. So one person from each team may rebut the other team's argument. Whoever wants to go in, then in no order of.
Kritika, you want to say anything?
Anoop, why don't you rebut?
Yeah, I don't know. I'm happy to. Yeah. Okay. Maybe since we spoke last, Anuba spoke last. Maybe those defending who made the first submissions. Maybe between Kritika, Shweta. Maybe one of you want to go first, and then. Yeah.
I think Ferry took a lot of time giving a reply to everything that I said. So, if I want to do
What is Anoop's answer? What is Anoop's answer to what Kritika said about Singapore and perhaps Venezuela? Venezuela?
Yes.
Yes. Anoop, I need your answer on that.
I did note that in my points. I think Kritika herself noted that Finland is first, if I'm not wrong. And Finland doesn't have the death penalty, right? So I guess that's my answer.
Probably doesn't have any people also.
No, I think it's on a more serious note in terms of it's. I think for me this debate goes down to the core question of how do we understand crime, right? What is crime? Is crime necessarily to be understood as bad people doing bad things, right? In that sense, and if we eliminate some people, if we eliminate enough number of people from our midst, society will be crime free. And I think Anubha was also making that point, and Kirti ma'am also made that point, that crime is produced socially, right? And in that sense, the reform that we need to ensure that the kind of gruesome cases that were referred to do not happen again is not more harsher punishment. These are very deep social, cultural problems. And these deep social, cultural problems cannot be resolved by legislating, right? And just harsher punishments is not going to solve that. And as Anuba said, victims need a lot of things, and very often the state uses it very, sort of very politically convenient manner to peg victims' rights against rights of the accused. And I think as far as we understand crime, if we understand crime and we understand that just eliminating some people doesn't mean that crime will not be produced again in society, I think then we start to make progress in terms of future direction. So, but as long as we think it's bad people doing bad things, so therefore just remove bad people, then I guess there is a fundamental disagreement.
No, so Anup, the whole argument being that if you remember in Nirbhay, only one newspaper went the way that one of the accused came from a family where he was the 5th, 6th, 7th child, had got no food, unwanted, ran away, etc. Now, that narrative got lost in this consciousness, the collective consciousness argument. So we, unfortunately, when I argued, first, what I tried to say was, where is that system in place that you are carrying out reform and rehabilitation? Unfortunately, you don't have that system. You don't have the mental ethos. You pick and choose something. You don't do empirical evidence. And then you say, abolish death penalty because we want to be seen as being good. No. You can't be seen as being good. You first become good. You first start bringing, I mean, how can you have juveniles? After all, your first reform will be with juveniles, right? So those who are in conflict with the law, or those who are are not in conflict, who are poor juveniles for the fact of their historical or their social ethos, are all dumped together and not a single thing is done for them. You see domestic violence cases, the DIR's reports are given by second year students of sociology. What are they going to do but reproduce what the complaint says? So we are not even one step there. We get there, we would, I would say, and I don't know whether for terrorist crime or not, but we'd say for all crime, okay, remove death penalty. I don't know about terrorist crime. I have a little confusion in my own mind on that. We're not in the debate now. I'm talking off the debate. But first, we have to have that reform in our system. We have to have rehabilitation. I have gone to Tihar for years and years doing social service. And I'm telling you that there is, maybe it's improved in these last few years when I haven't gone except once for a visit for, with one of the court benches which was going. Otherwise, there is no, and you can see that in the other jails, it's even worse in Patna and all. You bring an element of reform, bring an element of rehabilitation, then you can see about abolishing. But if you are going to only harden the criminals, which is what happened. I know in a case which I was handling, the person was accused of a small offense. He went in, he came out and committed a bigger offense. I know that Bobby Chor, for example, he was taken for 500, 600 thefts. But when he went back in, he said, look, I have become a more superior criminal, and come out. So the fact is, you are making them more hardened. Then you can't be saying that we want to be good. You are not being good. You are actually making most of them hardened. And every case is not a case of death penalty.
Sure.
It's very rare. Many cases where it will not be called for, honestly speaking, but the courts are not doing it in most cases. Circumstantial evidence, they are not doing it except in one or two rare matters. So I don't think they should do it in any circumstantial evidence case. But that's how our ethos is. But coming to your question, are there criminals who should be locked away, killed and murdered and forgotten as dregs because we as a society have produced them by not providing for them? Question is, what are we doing now? How are we providing for them now? How? By just making one cosmetic change and saying, okay, we will remove death penalty. How are we making them better? That's the whole ethos. Let's work to have reformation so that then you can look at the other aspect.
If I may just, for a moment, while I completely agree with, everything that you are saying, ma'am, and I think we are absolutely on the same page. But I do want to then say that while absolutely we are not doing enough to ensure that there is reformation and reformation as it should be, the cases, the scope for which death penalty is likely to be awarded, from the rarest of rare for heinous murders, we have really moved on and we have brought in so much more. I can even talk about the Shakti bill that was placed in Maharashtra, and it's now gone to the committee. It has included death penalty, and it has said that you will finish investigation in 15 days and you will finish the trial in 30 days. So the whole point is that while we are absolutely not doing enough, but we are also increasing the scope for what a death penalty can be awarded. And that is the absolutely most worrying trend then, because we are not acknowledging at all what we are required to be doing. And instead we are, every single time something happens, bringing in something more under the death penalty.
In
I'll
fact,
stop.
can I say something? In fact, the Maharashtra law brings in death penalty for acid attacks for the first time. And it also brings in death penalty per se for all rape offenses. It doesn't matter if it's adult rape, it doesn't matter if it's aggravated rape, it doesn't matter if it is child rape. All rapes are the same, all need death penalty, and we can see what is going to happen. We are going to be, yes.
Women's groups that are really insisting on this.
No, they are not. That's
No,
a
in fact,
misunderstanding. That's a misunderstanding. Women's groups.
There are a lot of women's groups which are saying this.
No, but I think you are in touch with maybe some, but I know.
I'm not talking, I am talking of social media, not lawyer groups.
Not lawyer groups. I'm talking
not
of
lawyer groups, but social media outrage.
I want to say all
even
the
women's groups in Maharashtra have in fact written to.
I know.
Yes,
in Bombay, they have written to women's groups.
But you have to see the social outrage groups.
No, the social outrage groups is something else. They are, there are lots of reasons why they're advocating that, and I won't go into that right now. They have a philosophy, they have an ideology.
I have talked to so many secretaries for women and child, so many of the ministers also.
In the present government, yeah. Okay.
Not in the present, in the present future. And I'm telling you, there are groups of of people who have a view and don't want to see another view. So there is a small element where you have stringent views. You're not talking of your lawyers.
No, I'm not talking of lawyers either. I'm talking of social action groups. I'm talking of the women's movement. I'm talking of people who traditionally fought for justice for the victim. I'm talking of those people. They are not in favor of this. And they have written to the Maharashtra government.
Soumya wants us to shut up after you finish.
No, not at all, ma'am. But in fact, I wanted to actually, in view of the time, take up 2 quick questions from the audience. They've been waiting, ma'am. So this is a never-ending debate, of course, unless the government puts an end to it, and still we'll keep debating about it. But
of course, Soumya, come on, go. Let's go.
So, Naomi, please go ahead and ask your question, and then after Naomi, Tara. Tara, you please ask your question after Naomi. Unmute yourselves and ask the question in that order, please. Naomi, are you there? All right, we move on to Tara. Tara, are you there? I believe both of them have left the meeting, but there is Orif Muzaffar. If Orif wants to ask his question. Orif?
Hi, can you hear me?
Please go ahead.
Yeah, this is for those who want to retain death penalty. Why is it hard for you, to demand capital punishment for the offenders in the Naroda Patia case? Some of them got, some of the offenders got bail from the highest court of India. How many of you remember the Gramsteinis case and the judgment thereof? If you also compare Asifa and Nirbhaya, just because a minister held a rally in favor of the rapists of Asifa, it suddenly shifted collective conscience in a different way. The thing is that what I want to argue is that there is already a picture of the criminal. He is poor, he belongs to the minority, he comes from the margins. The contempt for him is already there. So for those who want to retain death penalty, these are the questions they should also ask. If Indian civil society could come out for favoring death penalty for Afzal Guru, they should also come for death penalty in cases where there are hundreds of murders. For example, in the Naroda Patia case, 96 people were killed. Yeah, that's it. Thank you. Hello?
Who do you want this question to be replied by, Orif?
Hello. Those who want to retain death penalty. I mean, anyone can answer.
Shweta, will you answer? I didn't quite catch the question.
Basically, what I do gather from the question is that see, in a situation which you're talking, it's more like a public mass killing kind of a situation. Normally, what happens is in these kinds of cases, for example, in the case of riots, also the kind of evidence that we have is very circumstantial. And as we've all already concluded that it is very difficult to convict somebody for a harsh crime only basis the circumstantial evidence. I don't think that we can go that far and say that there should be death penalty for such a crime, because one, it will be very difficult to pinpoint the role of each and every person who has committed the crime on the spot. And also such kind of a trial is going to take some time. And also this case looks like it is sub judice right now, so we cannot really make a statement on it. I mean, it will not be correct because the court may be already looking at it.
Thank you, Shweta. I hope Orif's query has been satisfied. Kritika, I would ask this question to you on behalf of Tara, since you made a reference to this particular example that she is quoting in her comment. It goes like this. Although the pro-death penalty team argued that deterrence is not the reason to support death penalty, the examples given of various countries that have low crime rates because they have stringent punishments like losing a hand for theft demonstrates that reliance is being placed on the deterrence and not just retribution. Please comment.
Thank you for the question, Tara ma'am, and thank you, Soumya ma'am. First of all, I would like to clarify that how Geeta ma'am began the debate was that deterrence may be the wrong question that we are asking in the Indian subcontext. Now, I have not had the opportunity to study criminal justice system of the examples of the country that I quoted, but these are the examples which are often quoted and used in the UN when empirical debate and an empirical result is tried to reach upon. So, well, it may seem that the deterrence theory is what at least Singapore is following, but it seemed to be working for them. We might say that we are moving away from the deterrent theory and moving towards a reformative theory of crime. It seems to be it's not working from there for us. So this is a subjective question. I would like to say that what happens in those countries, but whatever they are doing seems to be working for them, and we can only learn and emulate the principles given our socioeconomic milieu and the unique problems, geopolitical problems that I have. So I'd leave it at that. Thank you.
Thank you to all the debaters. I now request Sunita ma'am to present the vote of thanks. Sunita ma'am.
Sunita,
okay. Yes, I thank our speakers for today for indulging us with this friendly yet forceful and fearsome debate on this topic, which as intellectuals, as practitioners of law, and as a human believers in human right, we keep having at various places. I thank Ms. Kirti Singh, Ms. Geeta Luthra, Dr. Anoop, Ms. Shweta Kapoor, Ms. Anubha Rastogi, Kritika Gupta, who are the speakers for today, and the moderator, Soumya Tandon, and Prachi Datta. The death penalty stays on the statute as a necessary evil, and the judicial dictum of strict, rarest of rare case, perhaps will be our guide in the next couple of years, till the time, of course, the debate is concluded. So the debate remains inconclusive, and with this is our 12th session, virtual canteen session, and the last for this year. I thank everybody, and we will be back next year on 15th of January with another session of virtual canteen. And I would like to thank all the members of the Delhi High Court Women's Lawyer Forum, and a special thanks to Nandita Rao, Mrinalini Sen, Suruchi Suri, Iram, Tanmay for all the behind the scene work. And I thank Bar and Bench for live streaming our session, which has made it possible for many of us to keep going back to the debates, the discussions, and keep listening to our speakers. Thank you very much once again. A Merry Christmas and a very Happy New Year.
A very Merry Christmas and a Happy New Year on behalf of the Delhi High Court Women's Lawyers Forum. Hope all of you have a safe and healthy 2021. Cheers to that.